We were discussing discretionary powers of the president. Next discretionary power. Next, right. President vis-a-vis the caretaker government. Vis-a-vis the caretaker government. Vis-a-vis the caretaker government. Now, yesterday I explained the concept of what is meant by a caretaker government. We said what? That because the constitutional position of the president is such that the office of the president cannot work without the council of ministers, and hence it becomes a constitutional imperative for the president to have a council of ministers, which was also declared by the Supreme Court in the UN Rao versus the Indira Gandhi 1971 case. And that is the reason why there is always a caretaker government that is in existence. Clear? However, this caretaker government does not enjoy the confidence of the Lok Sabha. This caretaker government does not enjoy the confidence of the Lok Sabha. Because the caretaker government does not enjoy the confidence of the Lok Sabha, that is the reason why this government is not allowed to take policy decisions. This government is not allowed to take policy decisions. It is very simple. How can a government, how can a set of individuals who do not enjoy the confidence of the Lok Sabha, no, legally or for that matter, ethically speaking, this particular institution will have no mandate for taking policy decisions. In a democratic country, only that set of individuals who are elected by the people and who enjoy, in India, who enjoy the confidence of the Lok Sabha, the political party that enjoys the confidence of the Lok Sabha, the council of ministers that enjoy the confidence of the Lok Sabha, only they are allowed to take policy decisions. And because this caretaker government, it is formed when either the Lok Sabha has been dissolved or the Lok Sabha is no more in existence, or if the concerned council of ministers have lost the confidence of the Lok Sabha. In both these cases, they do not enjoy the confidence of the Lok Sabha. Because they do not enjoy the confidence of the Lok Sabha, they are not allowed to take policy decisions. So what they do? They take up So what do? They take up or they take decisions which are only responsible or only affecting the day-to-day administration of the country. So they are taking only those decisions which are affecting day-to-day administration, but they are not taking decisions which are policy decisions in nature. Clear? Now, so what is the discretionary power that the president enjoys in this regard? the president enjoys the power to decide what is day-to-day administration. What is day-to-day administration, or what are those decisions which are affecting day-to-day administration, and what are those decisions that are policy decisions? This becomes the discretion of the president. This becomes the discretion of the president, and if the president feels that this decision of the Council of Ministers, it is a policy decision, the president may not work in accordance to the advice given by or tendered by the Council of Ministers. So in this case, deciding what amounts to day-to-day administration, this becomes a discretion of the president. Clear? This becomes a discretion of the president. Clear? So vis-a-vis the caretaker government, the president enjoys the power. You can write this. Vis-a-vis the caretaker government, the president enjoys the power. The president enjoys the power to decide. Enjoys the power to decide what decisions of the government are necessary, what decisions of the government are necessary for carrying out day-to-day administration of the country. Day-to-day administration of the country. This is so because the caretaker government does not enjoy the confidence of the Lok Sabha, and therefore is not expected to take policy decisions. See, the last discretionary power or last situational discretionary power is with respect to dissolution of Lok Sabha. With respect to the dissolution of Lok Sabha. See, till the time the Council of Ministers enjoy the majority or confidence of the Lok Sabha, in that case, who recommends the President to dissolve the Lok Sabha? It is the Council of Ministers. And till the time the Council of Ministers enjoy the confidence of the Lok Sabha, it becomes mandatory for the President to act in accordance to the decisions or the aid and advice given by the Council of Ministers. However, if the Council of Ministers have lost confidence of the Lok Sabha, in that case, the President may act in accordance to his discretion and not in accordance to the advice given by the Council of Ministers. This has been made clear by the Supreme Court in Viplav Sharma versus the Union of India 2004 case. See, in 2004, the then NDA government that was there, so it was led by Atal Bihari Vajpayee. And Atal Bihari Vajpayee, he called for elections 6 months in advance. That means the tenure of the Lok Sabha scheduled completion of the tenure of Lok Sabha was in the month of somewhere around the month of October, November, and he called for elections in the month of April. He called for elections in the month of April. Basically, there was a campaign that was taken up by the then NDA government. The campaign was about India Shining campaign. No. And accordingly, the campaign, according to them, it was received well. It was received well. And there were elections also that happened in the state legislature, state of MP, the state of Chhattisgarh and the state of Rajasthan. No, there were 3 or 4 states wherein elections had happened, and in all these states BJP had won elections. Now they clean swept elections in all these states. So the central government was of the opinion that if we announce elections as of today, very likely that we are going to win elections. So they did what? They called for elections 6 months before the scheduled completion of the Lok Sabha. When they recommended the president to dissolve the Lok Sabha and call for elections, this was challenged in the court. Because the constitution says that the Lok Sabha is going to have a tenure of 5 years. The constitution says under Article 81, the constitution says that the Lok Sabha is going to have a tenure of 5 years. So this was challenged, that can the Council of Ministers call for an early elections 6 months in advance? And the Supreme Court in the Viplav Sharma case said that if the Council of Ministers enjoy the majority in the Lok Sabha, it is upon them that whenever they can recommend the president whenever to dissolve the Lok Sabha and call for elections. However, if the Council of Ministers do not enjoy the majority, in that case it becomes the discretionary power of the president to whether to call for elections or for that matter to dissolve the Lok Sabha or not. To dissolve the Lok Sabha or not. See, there is a simple logic behind it. Suppose there is a coalition government that has been formed. There is a coalition government that has been formed, and this coalition government, one of the political parties withdraw from it, and that particular coalition loses majority in the Lok Sabha. So rather than opting for proving whether they enjoy the majority or not, they can recommend the president dissolve the Lok Sabha. And if in this case the president dissolves the Lok Sabha, it may so happen that that is not a legitimate, that is not legitimate. Why? Because it may so happen that the other political party or the coalition of parties, they may be in a position to form the government. Without elections, they may be in a position to form the government. And if this is the case, it will not be legitimate for dissolving or to dissolve the Lok Sabha. And hence, when the Council of Ministers do not enjoy the majority in the Lok Sabha, then it becomes a discretionary power of the president. Then it becomes the discretionary power of the president. See, this has previously happened also. This has previously happened also. There were recommendations during the 1990s when India was going through a political instability, a phase of political instability. There were circumstances in which the Council of Ministers had recommended the president to dissolve the Lok Sabha, but rather than dissolving the Lok Sabha, the president has done what? The president has asked the Council of Ministers to prove majority in the Lok Sabha. Clear? So the situation is very clear. If the president is recommended to dissolve the Lok Sabha by a Council of Ministers who enjoy majority, the president has no choice but to dissolve the Lok Sabha. But if the Council of Ministers do not enjoy majority, then the president has discretion whether to dissolve the Lok Sabha or not. Clear? Write this down. As per conventions, the president dissolves the Lok Sabha only on the advice of the Council of Ministers. Only on the advice of the Council of Ministers. However, in the Viplav Sharma versus the Union of India, 2004 case, the Supreme Court pointed out that the President cannot dissolve the Lok Sabha. The President cannot dissolve the Lok Sabha without the advice of the Council of Ministers. Without the advice of the Council of Ministers, if the Council of Ministers enjoy majority in the Lok Sabha, if the Council of Ministers enjoy majority in the Lok Sabha. However, when the Council of Ministers have lost the confidence of the Lok Sabha, the President may not act. The President may not act in accordance to the advice of the Council of Ministers. In accordance to the advice of the Council of Ministers. Clear? With this, we complete our discussion on the discretionary powers of the President. And we move to the next topic, that is Ordinance Making Powers. Ordinance Making Powers. So does the President of India, constitutionally, does the President enjoy discretionary powers? No. Only situational discretionary. Ordinance making powers. This is enjoyed by the President under Article 123 of the Constitution. Under Article 123 of the Constitution. There is no need to write this until unless I say so. Please just understand this. This is a very important topic because there have been number of cases of the President promulgating ordinance. The constitutional term that is used is not ordinance making but promulgation of ordinance. The term that is used is promulgation of ordinance and not ordinance making. First, let's understand what does Article 123 of the Constitution say. See, Article 123 of the Constitution says that when both the houses of the Parliament are not in session. So the first condition that Article 123 imposes is that both the houses of the Parliament shall not be in session. When both the houses of the Parliament are not in session and the President is satisfied, the second condition is if the President is satisfied that there is a need of an urgent law. So what is the third condition? Now the third condition is that there is a situation that demands an urgent law. Clear? So if the President is satisfied on what? When the two houses, both the houses are not in session and the fact that the President feels that there is an urgent need of the law, the President can promulgate ordinance. The President can promulgate ordinance, which means what is an ordinance? Ordinance is nothing but a temporary law. Now, when I say ordinance to be a temporary law, why? Why am I saying this? Because if you further see what Article 123 says, further Article 123 of the Constitution says that such an ordinance shall be presented before both the houses of the parliament, presented and passed before by both the houses of the parliament before the expiry of 6 weeks since the first meeting of both the houses. So when the parliament is reconvened, when the parliament is summoned again, remember yesterday we talked about Article 85. So when the parliament is summoned back again, this ordinance that is there, this ordinance that has been promulgated by the president, it has to be passed by both the houses of the parliament, not one house, both the houses of the parliament within 6 weeks, after the house has for the first time met. So as soon as the house is summoned, 6 weeks from the first meeting, it has to be passed by both the houses of the parliament. If it passes by both the houses of the parliament, it goes to the president. The president may sign the bill, and the ordinance which was previously an ordinance now becomes an act of the legislature, a law. However, if both the houses of the parliament have not passed the law within 6 weeks, the ordinance lapses. When both the houses have not passed it within 6 weeks, the ordinance lapses. What does that mean? It means it is no more enforceable. The ordinance is no more enforceable. And that is the reason why we say ordinance is a temporary law. Ordinance is a temporary law. Why? Because the validity of the ordinance is 6 weeks. No, from the time it has been promulgated by the president till 6 weeks of the first meeting of the new the reconvened or the new summoned parliament. As soon as it is summoned, 6 weeks from that day, the ordinance will be enforceable. If it is not passed within 6 weeks, it becomes non-enforceable, it lapses. The term that we use is it lapses. Clear? So it is no more enforceable. Now, this is the reason why we say it is a temporary law. It is a temporary law. What is the difference between an ordinance and an act of the parliament? The only difference between an ordinance and the act of the parliament is that act of the parliament is permanent. It is permanent. It will remain in effect, and it can only be changed again by a law. So if there is an amendment act passed, only then it can be changed. Otherwise, it is permanent in nature. Whereas what is an ordinance? Promulgated by the president but is not permanent. Why? Because what is the time period? 6 weeks. 6 weeks after the parliament has been convened. After 6 weeks, it lapses. If it is passed within 6 weeks, now it becomes a law. So it's no more temporary in nature. It becomes a law. Clear? So what is ordinance making power? Ordinance making power is like a flexibility. It is like flexibility given to the executive, that is the President of India, so that if suppose the legislature is not in session, for whatever reasons, the legislature is not in session, and the president feels that yes, this is a time that requires an urgent law. So rather than convening the parliament and then passing the law, it may be necessary to pass the law or to enforce the law just by an executive order. And that is what the president does. He promulgates an ordinance. The power to promulgate an ordinance that the president enjoys is not his discretionary power. It is not his discretionary power. He will enjoy such powers only when advised upon by the Council of Ministers. The Council of Ministers advises it, and only then the president promulgates an ordinance. Clear? Now, what happens if the ordinance is not passed by the House within 6 weeks and it lapses? What happens? According to the Supreme Court, the ordinance or the acts that have been done when ordinance was in force, it is still valid. Those acts are still valid, and it will not be declared unconstitutional or invalid ab initio. That means from the start of it, when it was born, till the time it was in effect, till that 6 weeks period, it will be as enforceable as a law. It will be as enforceable as a law. So any act that has been done by the executive, that has been completed by the executive during the ordinance was in force, or when the ordinance was in force, that act still remains despite the fact that the ordinance may lapse after 6 weeks. That law still remains. By the 38th Constitutional Amendment Act, which was taken up in 1975, there was a provision added to Article 123, Article 123 Clause 4, and the Article 123 Clause 4 said that such an ordinance or any ordinance which is promulgated by the President will not be questioned before any court of law. It will not be questioned before any court of law. By the 44th Constitutional Amendment Act, this provision was repealed. Before the court could declare it null and void, it was not declared null and void, but the 44th Constitutional Amendment was passed in 1978 and they removed the provision. 123 Clause 4 was removed. As it is, in the A.K. Roy case in 1982, there was a very famous case on the ordinance making power of the President. And in this particular case, the Supreme Court actually elaborated upon the ordinance making powers. And the Supreme Court first of all said that such powers that the Parliament, that the President enjoys, that power is an legislative power of the President, not an executive power. It's not an executive power of the President, it is the legislative power of the President. Second of all, in the A.K. Roy case itself, the Supreme Court declared that any ordinance that is promulgated by the President, it is subject to judicial review, which means it can be reviewed by the Supreme Court. The constitutional validity of the ordinance can be reviewed by the court. Further, the court also said that the court established a procedure or the manner in which this can be reviewed. And what was the manner that the court established? The court said that as soon as an individual challenges an ordinance, that means if suppose the President has promulgated an ordinance, and I challenge the ordinance, that there is no need for an urgent law, so you should not promulgate it. If I go to the court, I go to the Supreme Court and I am challenging this ordinance, the court will first say, you have to, that means the individual who has challenged the ordinance will have to prima facie establish. What is the meaning of the term prima facie? On the face of it. It means on the face of it. So initially, I, who is challenging the ordinance, will have to establish that there was no urgent need of a law. If I am able to establish it, if the court is satisfied with my argument, only then the burden of proof shifts from the individual who challenges to the court, to the President. And now the President will have to prove what were the circumstances that were necessary or that necessitated the President to promulgate an ordinance. What were the circumstances that forced or necessitated the President to promulgate an ordinance? This will be done only after, as an individual who has challenged the ordinance has prima facie established that there was no need for an urgent law. There was no need for an urgent law. And then the President will come up with certain circumstances, and it will see whether, the court will see whether it is justified or not. And if the court feels that there was no need for an urgent law, the court will declare the law to be, the ordinance to be unconstitutional. But if the court is not satisfied with the argument of individual who has challenged it, or is satisfied with the argument that the President presents, the court will declare the law or the ordinance, this temporary law, to be constitutionally valid. Clear? This is what Article 123 of the Constitution is, as well as what in the A.K. Roy case, the procedure that was established by the Supreme Court to challenge the constitutional validity of the ordinance. Clear? Understood this? Have you understood what is an ordinance? Ordinance is nothing but a temporary law. The best way to define it, that it is nothing but a temporary law. Why? Because once the ordinance is in force, till the time the ordinance is in force, it is as enforceable as any law. But ordinance is unlike a law, it is temporary in nature, because if it is not passed within 6 weeks, then it lapses. So the best way to define it is that it is an temporary law. The ordinance making power of the President, it extends to, ordinance making power of the President extends to all the legislative jurisdiction of the Parliament. So whatever falls under the legislative jurisdiction of the Parliament, the President can promulgate ordinance in any of those subjects. So whatever is mentioned in the union list, in all those cases, the President can promulgate an ordinance. Clear? Yes. No, not necessarily. The individual can challenge the ordinance on this ground also, that it was not necessarily needed, or it was not an urgent law that was required. The circumstances that are there, that can also be challenged. Yes, it can be, obviously, because it is passed by the Parliament, President. So you are going to challenge it where? In the appropriate court. So in this case, it will be the Supreme Court. Now, have you understood this idea? Clear? Now, let me present you with some facts on how ordinance making power of the President is exercised. In 2013, when the UPA government was outgoing, that means elections were due in 2014. So when it was outgoing, in that case, the UPA government passed a law called as Land Acquisition Law. Land Acquisition Act was passed. That means in this particular act, basically certain necessary conditions were laid down as to when the government can acquire land, and what are the conditions that needs to be fulfilled by the government to acquire land. This was something that was mentioned in the Land Acquisition Act. It said, the Land Acquisition Act said, first of all, agricultural land cannot be acquired by the government. Agricultural land can only be acquired if it is to be used in public purposes or public interest. Example was also, it was elaborated what is public interest, and mainly if you are using it for defense purposes, only then you can acquire agricultural land. Even when you are acquiring non-agricultural land, some commercial land, non-agricultural land, for giving it to business enterprises, because the government tends to do that, they acquire land, they give it to business enterprises. Now, if you remember, going back around 15-16 years, there was a case when in West Bengal, Singur, there was a district in Singur, and their land was to be acquired. It was acquired by the government to be given to Tata for establishing their nano plant. So Mamata Banerjee agitated against it, and there was large scale violence, etc., and finally Mamata Banerjee's political career was established. Now this was the very reason. Otherwise, if you go back to before that, it was completely dominated by the left parties in West Bengal. Since independence itself, for few years Congress party was there, and after that in West Bengal, for almost 35 to 40 years, the left parties ruled West Bengal, and it was Mamata Banerjee who defeated them. But the defeat was there, it was because of this. The left parties had given acquired land, agricultural land, and it was given to to Tata. Finally, the Singur agitation that happened, it was successful, and the company itself, Tata itself declined. It said that I am not going to establish the plant there. No, the then Chief Minister Narendra Modi of Gujarat, he said that you can come to Gujarat and we are going to give you land. And that is the reason why right now the Tata manufacturing that is there with respect to nano, it is not in West Bengal, it is in Gujarat. Clear? Now, the government used to do what? The government previously used to acquire agricultural land, and this was something that was that created lot of dissatisfaction among people whose land were being acquired, because their sole vocation was agriculture. इसके अलावा उनको कुछ पता नहीं था, and suddenly you are trying to do what? You are acquiring their land, despite the fact that yes, you are compensating them, but that compensation, that compensation that is there, no compensation can be enough, because that is what they have been doing since long. So they are cultivating that land, and accordingly their livelihood is dependent on them. But the government was previously acquiring this agricultural land, and it was given to business enterprises. The UPA government said this will not be done except for certain purposes. One or two purposes was mentioned, and agricultural land was prohibited from being acquired. Even the non-agricultural commercial land that was there, to acquire the non-agriculture commercial land to be given to business enterprises, the provisions of the law that was there, it made it very stringent and very difficult for the government to acquire land. Like, it instated provisions such as that the land that is there to be acquired, at least 70 or 80% of the owners of that land should agree to the government acquiring that land. If they do not agree, 70 to 80% of them, if they do not agree, in that case, that land cannot be acquired. Similarly, when the government is paying compensation, so compensation is to be paid not only to the owners of the land, but even those individuals whose livelihood is dependent. Which means, if there is a shop in that particular area, in that land which is to be acquired, that shop is on rent. So the individual who has rented that will also get compensation from the government. It made it very difficult for the government to acquire land. As soon as in 2014 election results were declared, obviously the NDA government came to power, and the NDA, one of the very first steps that they did was they wanted to amend the Land Acquisition Act. So they came up with something called as Land Acquisition Amendment Bill. Clear? And because they had the majority in the Lok Sabha, it was easily passed from the Lok Sabha. But they did not have the majority in the Rajya Sabha. They even today do not have the majority in the Rajya Sabha. But they knew that if I present the bill in the Rajya Sabha, it is going to be defeated. And because it was one of the first steps that were taken by the newly formed government, what they did was they passed it from the Lok Sabha and waited. When the parliament was on a break, as soon as both the houses were prorogued, they passed it as an ordinance. The president promulgated it as an ordinance. Fine. Now, because of this ordinance, there were a lot of problems. Whatever this government has done since the first act itself, there were a lot of there is lot of agitation against it, etc., etc. That happened with the Land Acquisition Amendment Act as well, Amendment Bill as well. When it was passed as an ordinance, there was agitation, etc., etc. And when the Parliament was reconvened, the government did not present it in the Rajya Sabha again. They waited. The bill lapsed. They waited. As soon as the Rajya Sabha, both the houses were prorogued again. They re-promulgated it as an ordinance. Rather than it being passed by both the houses, or no, allowing it to be passed by both the houses, they did what? They did not initiate any kind of deliberation in the Rajya Sabha. They did not initiate any kind of deliberation. It was not even introduced, it was not even put up for debate and discussion in the Rajya Sabha. It was passed by the Lok Sabha. And because, again there were some problems with the bill, so it went back to the Lok Sabha. It was passed again by the Lok Sabha with some amendments. It was passed again by the Lok Sabha, but it was never presented in the Rajya Sabha. Rajya Sabha did not get the opportunity to debate and discuss the bill. And once the houses were prorogued, what happened? It was re-promulgated. What does this mean? If you look at this particular act of the government, what does this mean? Re-promulgation of ordinance without presenting it before the second house, debating, discussing the bill. It is being re-promulgated by the as soon as the parliament is not in session. As soon as both the houses are not in session, it is being re-promulgated. What does this mean? It means that through the use of ordinance making power of the president, the government is trying to bypass the democratic standards. It is going to, what is it doing? It is trying to bypass it. How? In the form of an ordinance. In the form of an ordinance. It is going to be bypassed. And this happened. There was another way. What was the another way, if the government felt that, okay, this bill is necessary, it is, appropriate, it is absolutely fine. You have your own political agenda. You have your own political ideology and you are going to adhere to. Every political party does that. That is absolutely fine. But what you could have done is, you could have presented it before the Rajya Sabha. At least giving them the opportunity to debate and discuss it. Debate there, discuss there, and even if the bill was defeated in the Rajya Sabha, the government still had a choice. What was the choice? Calling for a joint session. Because we are going to discuss this. Article 108 of the Constitution says that when there is a deadlock between both the houses, so there can be a joint session that can be called, and in that joint session the bill can be put to vote. If this particular bill that was there, if it would have been defeated in the Rajya Sabha and the government could have called for a joint session, if it would have called for a joint session and then put the bill to vote, it would have been passed. Why? Because it then requires what? Simple majority. And which means what? If you look at 545 members in the Lok Sabha and 245 members in the Rajya Sabha, which means somewhere around 790 members. 790 members, which means you require the support of somewhere around 400 MPs, less than that, even less than 400 MPs in the Lok Sabha as well as in the Rajya Sabha. In both combined you require that much, and out of that you had more than 330 seats in the Lok Sabha and you had somewhere around 60 seats in the Rajya Sabha. So you had that majority. And you could have done that, like the government did when it came to the J&K reorganization bill. No, it was presented in the Rajya Sabha. Despite the fact that the government did not enjoy majority in the Rajya Sabha, it was passed by the Rajya Sabha. Still, similarly, when it came to the Citizenship Amendment Act, this bill, when it was a bill, it was presented in the Rajya Sabha. Rajya Sabha government did not enjoy majority, but it was still passed. Why? Because the government did what? They took up various political parties, they engaged in various kind of lobbying, etc., and accordingly they ensured that the bill passed. You could have done that for the Land Acquisition Amendment Act as well, but it was bypassed and it was re-promulgated. The ordinance was repromulgated. What does this mean? It means through the promulgation power, the power that has been given to the president under Article 123 of the Constitution, you are trying to bypass the democratic standards. You are trying to bypass the democratic norms. And this is not something that has been done only by one political party. Again, I am telling that. Though I am giving you a recent example, but this is not the only thing. This has not been only a case wherein ordinance has been used by the government to bypass the democratic standards. There have been number of cases previously also. The outgoing government, the UPA government that was there, the UPA 2 government that was there, they tried to amend the criminal procedure code by passing an ordinance. Rahul Gandhi tore that ordinance in front of the media. That was also not in accordance to what the democratic standards opt for. So this is not it's not to say that promulgating ordinance or ordinance making power is not important. It is, and that is the reason why it has been included under Article 123. What did I say? It provides flexibility. It provides flexibility. Why? Because there are certain conditions that are imposed on which it can be taken up. But the manner in which it has been used, it points out to the misuse of ordinance making power. It points out to what? The misuse of ordinance making power. And accordingly, the Lok Sabha has come up with a procedure wherein whenever an ordinance is introduced in the Lok Sabha to be voted upon, that means within 6 weeks when it is introduced in the Lok Sabha to be voted upon, in that case, the government, while introducing the ordinance, will also introduce an explanatory memorandum along with it, wherein it would explain the circumstances that are necessary, that were necessary to promulgate that very ordinance. And obviously in the A.K. Roy case, in the A.K. Roy versus the Union of India case, 1982 case, the Supreme Court also declared that it is under the purview of judicial review. So you can challenge the constitutional validity of an ordinance as well. My question is that if this is the case, I very boldly in the class said that this example that was there, land acquisition amendment bill that was there, it was repromulgated as an ordinance. And I said it is bypassing the democratic standards. The question remains, or the question is, why was it not challenged in the court then? Why was it not challenged in the court? Because in the A.K. Roy case, the Supreme Court declares that any ordinance that is to be passed by the president or promulgated by the president, it is subject to judicial review. So why is it that when everything is being appealed in the court, any act that has been done by the parliament, the Citizenship Amendment Act, it has been appealed in the Supreme Court, the Triple Talaq bill, bill that was there, the act that is there, it has been appealed in the Supreme Court. Again, the 10% reservation, the 103rd Constitutional Amendment Act, that was also appealed in the Supreme Court. Article 370 and the amendment to Article 370, that has also been appealed in the Supreme Court. Why is it that these ordinances that are there, why are these ordinances not appealed? Yes. Why do you think it is not appealed? That is what I am saying. The very basis of it, that is, if there is an urgent requirement of a law, that is the very basis of it. Because the basis of it, you can always question this idea that why was it urgently required? Land Acquisition Amendment Act or bill, why was it urgently required? Why is it that it is not, you will not hear such an appeal? Why? Any ideas? Any ideas? Do you think political parties are that rational? आपको लगता है पॉलिटिकल पार्टीज इतना रैशनल तरीके से सोचते हैं? उनको तो बस कुछ करना है, उनको क्या मतलब है कि ये क्या रैशनल है क्या नहीं है? Do you think political parties are that rational? See, whenever we talk about amendments or ordinances, whenever we talk about ordinances that are there, that are promulgated, to challenge ordinance, you don't have to have a valid reason for the ordinance. It is when it is urgently required or not. Whether the act is logical or not, that is a different thing altogether. When you are challenging the ordinance, you are challenging you have to prima facie establish whether it was urgently required. What do you think is the reason? The reason is that if you look at the decisions of the Supreme Court, whenever the Supreme Court always assumes that whenever the executive is acting or whether the legislature is acting, they are always acting with good intention. This is always assumed. This is always assumed. So if you try and challenge the decision of the executive, that is the president, on the basis of its intentions, that will never be upheld in the court. The court will never uphold that. Why? Because the court says, the court assumes that it was the law that has been enacted, it is always enacted with good intention. Whether the law is justified or not, that is a different thing altogether. But you cannot assume, the court will never declare that the executive's attention was, the executive's intention was something that was wrong. This is always the case, and that is the reason why it becomes very difficult to question this very idea. Why? Because the court assumes that executive or the legislature, whenever it is acting with good intentions. There are no bad intentions that are involved. Clear? There is a Latin term to describe it, but that is not needed. Clear? So this is the very reason, and in the A.K. Roy case, the Supreme Court declared that also, that we are ever, when the ordinance is being challenged, it cannot be challenged on the basis of its intention, because we assume that executive and legislature is always working with good intention. Yes, sometimes it may so happen that the legislature comes out with laws which are not justified, which may not be legal or which may not be justified, but this cannot be considered. It cannot be considered that they are acting with bad intention. That cannot be considered. Clear? Clear? This is the ordinance making power. There was a question that was asked in 2015. The question was with respect to this misuse of ordinance making power. But there are some checks that have been imposed within the constitution itself. The first check is what? The first check is when both the houses of the parliament are not in session. So if suppose the Lok Sabha, the Rajya Sabha is in session, but Lok Sabha is not in session. So can the president promulgate an ordinance? No, they cannot. Why? Because the constitution is very clear, when both the houses are not in session. Clear? When both the houses are not in session. So some checks that are there, it has been imposed by the constitution itself, like when there is an urgent need of a law, when both the houses are not in session. Similarly, when the president is satisfied. These are the conditions that have been imposed, and a condition that if it does not pass within 6 weeks of reassembly of both the houses of the parliament, then in that case the ordinance lapses. Along with it, the check that has been imposed by the judiciary is that it is subject to judicial review. And the check that has been imposed by Lok Sabha is that the Lok Sabha demands that whenever an ordinance is presented or for it being voted upon, in that case the legislature will, along with the ordinance, present and the executive along with the ordinance will present an explanatory memorandum as to why was there an urgent need of the ordinance. Clear? These are some checks that are there on the ordinance making power. But yes, it is misused. That is not to say political parties tends to misuse everything. So they misuse this also. Clear? It is misused by every political party that comes to power. There is no one political party that you can say have misused this. Every political party that has ever come to power have misused the ordinance making powers. If it is again and again re-promulgated, yes, it can. There is no check. There is no precedent for this. That first of all, it has never happened. Second of all, if you look at the constitution does not impose any check on re-promulgation. That no, it cannot be re-promulgated. This is not something that has been mentioned. So yes, it can. Technically speaking, yes, it can. Whether the court allows it or not, that is a different thing altogether. But technically speaking, yes, it can. It can be re-promulgated n number of times, unlimited. See, no law can be challenged on the basis, no law is challenged on this basis, because there is no objective basis to establish intention. What is the objective basis to establish intention? How can you establish that? There is no objective basis to establish intention of the government.
Challenge the intention.
See, they will not challenge the intention. They will challenge the idea that there was no urgent need of the law. So suppose I go to the court, I will say I might prima facie establish this in this manner, that suppose the ordinance was presented and it was re-promulgated after once it was made to lapse and then it was re-promulgated. So I might go to the court and I will say that, see, if it was an urgent law, if there was a requirement of an urgent law, in that case there are number of other things that the government could have done, like at least presenting it before the Rajya Sabha and getting it voted upon. If it was not voted upon by the Rajya Sabha, it means, it shows that there is no urgency with respect to the law. So I can challenge it in that manner also. But obviously there are some technical glitches that are there, but I can challenge it in that manner. Whether the court agrees to my challenge or not, that may be different. Clear? Write this. Promulgation of ordinances. Article 123 empowers the President to promulgate an ordinance when both the houses of the Parliament are not in session. Not in session. Every ordinance promulgated by the President, shall be presented to both the houses, for approval. An ordinance shall cease to be in force at the expiry of 6 weeks after the Parliament reassembles unless within this period both the houses of the Parliament approves the ordinance. Once approved by the Parliament, the ordinance becomes a law. Therefore, the only difference between the law and an ordinance is that ordinance is temporary, whereas law is permanent. Ordinance is temporary, whereas the law is permanent. The President can promulgate an ordinance. The President can promulgate an ordinance. Promulgate an ordinance on any subject. On any subject where the Parliament exercises legislative jurisdiction. Exercises legislative jurisdiction. However, the ordinance making power of the President, is not a parallel power of legislation. The ordinance making power of the President is not a parallel power of legislation available to the President while the Parliament is capable of making laws. Next paragraph. According to the Supreme Court, if an ordinance is allowed to lapse, without being placed before the Parliament, it cannot be treated void ab initio. I have used the term ab initio before also when we were discussing doctrine of eclipse. Ab initio, and all the acts done and completed when the ordinance was in force, shall continue to be valid. Next paragraph. The 38th Constitutional Amendment in 1975 introduced Article 123 Clause 4, which stated that the ordinance promulgated cannot be questioned. In any court of law. The 44th Constitutional Amendment Act 1978. The 44th Constitutional Amendment Act 1978 repealed this provision. The Supreme Court in the A.K. Roy versus the Union of India 1982 case also held that the satisfaction of the President under Article 123 is subject to judicial review. Under Article 123 is subject to judicial review. However, the person who challenges the constitutional validity the constitutional validity of the ordinance shall have to prima facie establish the non-existence of the circumstances necessary for the promulgation of ordinance before the court transfers the burden of proof to the president which circumstances necessitated the promulgation of ordinance. The court has also clarified that the power to promulgate an ordinance is not an executive but a legislative power of the president. Next paragraph. In order to prevent the misuse of ordinance making power, the Lok Sabha has made a rule requiring that whenever the government seeks to replace an ordinance by a bill, it shall contain a statement of object. Explaining the circumstances which has forced the president to promulgate the ordinance. Yes. One more thing before I actually end the topic, President. Please go through some other cases that have been taken up by the Supreme Court for ordinance making power. There are some cases that have taken place, like DC Wadhwa case, etc. What you also need to do is read the ordinance making power of the president along with the ordinance making power of the governor. Promulgation of ordinances by the president, read it in accordance to the ordinance making or ordinance promulgation power of the governor. Why? Because there are some cases in which the president, when the Supreme Court has actually referred to those cases, they have compared the ordinance making powers. They say that it is similar to the president, etc., etc. There have been some cases. Clear? So please go through that. Clear? Please go through that additional cases. In 2000, I think it was in 2016, what happened was that rather than mentioning an article, in UPSC what they did was they asked a case. Now everyone remembered articles, but they did not remember the case. It was, there was a case that was asked, Kohilo case. Now that case was with respect to the decision. There was some aspects he dealt with, and that case was asked rather than asking the article or the very idea. So this is sometimes UPSC tends to do that as well, and that is the only reason why I am telling you that at least in this particular topic, please go through some other cases as well. Clear? Next, with this we complete our discussion on the president. I am repeating myself. I have not dealt with the functions of the president, functions and duties of the president. Please refer Lakshmikant topic, this topic president there. Please refer to the functions and duties topic that are there. Please refer it there. Clear? Because no, it will be a repetition. I am going to talk about some other provisions later on, and there will be a repetition. So I don't want to do that. And as it is factual in nature. You have to learn it. Clear? Please go through that. Next, we start with Council of Ministers. Before that, I'll give you an introduction about Vice President. There is nothing to write there. There is no. This office is not that important for our examination purpose, or for that matter otherwise also. But I'll give you an introduction about Office of the Vice President, and we are also going to compare this office with the Vice President of US, and we are going to see what are the similarities that are there. So Vice President of India, like the President of India, is an elected body. How is the Vice President elected? Again, like the President, he is also elected through indirect elections. Again, there is an electoral college, and in this electoral college, who votes? So who are the members of the electoral college who vote to elect the Vice President? The members of the Parliament. The members of the Parliament, not the members of the state legislative assemblies. And I am not saying the elected members, which means any individual who is a member of the Parliament will vote, whether he is elected or appointed, it does not matter, he votes. What is the what is the office of Vice President? What is its primary duty? The office of the Vice President primarily acts as the Chairman of the Rajya Sabha. He is the presiding officer of the Rajya Sabha. He is the presiding officer of the Rajya Sabha. The office of the Vice President does not have any duty except to act as the presiding officer of the Rajya Sabha. So he is not the Vice President. Basically, his duty is to act as the presiding officer of the Rajya Sabha. Constitutionally speaking, the Vice President does not have any duty. It is the office of the presiding officer of the Rajya Sabha, that is Chairman of the Rajya Sabha, who has certain duties. He acts as the Chairman of the Rajya Sabha. Otherwise, as Vice President, he does not have any duties. Clear? Elected by the members of the Parliament, and he is removed under Article He is removed under Article 69 Clause 3. Have we dealt with this article before? When? We were talking about majorities. So how is the Vice President removed? Vice President is removed by the remember this, by the Parliament. However, the process is initiated when a resolution is introduced for this effect in the Rajya Sabha. In the Rajya Sabha, and Rajya Sabha passes this resolution by an Rajya Sabha passes this resolution by an effective majority, not by simple majority, not by absolute majority, not by special majority, by an effective majority. Once the resolution is passed by the Rajya Sabha, the Lok Sabha has to agree to it. The Lok Sabha has to agree to it. The term that has been mentioned, the expression that has been mentioned in the constitution is that the Lok Sabha has to agree to it. That's it. This has been mentioned. But we assumed that again it will be through an effective majority if the Lok Sabha also passes a resolution. After the Rajya Sabha has initiated the process, the Vice President is removed from office. Clear? See, the only thing that the Vice President does is that the Vice President acts as the presiding officer of the Rajya Sabha. The Vice President discharges the duty of the President in his absence. Additionally, when the President is not present for whatever reasons, if the President is not able to discharge his duties as the President, the Vice President acts as the President. So suppose the President of India is not in office because of, suppose he is out of the country. When the President is out of the country and is unable to discharge his functions, his duties, if he is unable to discharge his duties, then the Vice President will act as the President. Vice President will act as the President. If the President is outside the country and is able to discharge, Vice President does nothing. Vice President will act as the President only if the President is suppose outside the country and unable to discharge his duties, or if the President passes away in office. If the President passes away in office, in that case the Vice President becomes the President. He discharges the duties of the President until unless a new President is elected. He acts as the acting President. He acts as the acting President. Clear? This is the only duty that he has. The only duty that he has. Clear? Now, if you compare the office of the Vice President of India to the Vice President of US, there are some dissimilarities that are there, and there are some similarities. What are the dissimilarities? Let's look at how the Vice President of US is elected. Vice President of US is not elected. There is something called as, in US, this is the practice. The President of the, any individual who is basically contesting to the office of the President, he has something called as a running mate. He has something called as a running mate. There is an individual who becomes his running mate. That means he also, he helps basically the President to get elected. And the President declares that he is my running mate, which means if the President gets elected to the office of the President, that individual automatically takes he is administered the oath of the office of the Vice President. He is not elected there. It's like electing the President along with his running mate. So the Vice President gets appointed to the office by the President. Rather than being elected, he gets appointed to the office by the President. But unlike that of India, if suppose if anything happens to the President, whatever reasons, if suppose the President dies in office, the Vice President becomes the President, and he will discharge his duty as the President till the completion of tenure. So it's not that elections are going to happen. No. If suppose the President is there and the President will serve a tenure of 4 years, but if the President dies, in that case the Vice President is sworn in as the President, and he discharges his duty as the President till he completes his tenure. Clear? Clear? Suppose the president is impeached. Right now impeachment proceedings are going on. It's very likely that at least in the House of Representatives the impeachment proceeding is going to pass. If it so happens during our classes are going, when our classes are going on, I'll be dealing with how it happens. Okay, what is the procedure? If not, it's not that important. But okay. If the president is impeached, who acts as the president then? The vice president. It is the vice president. See, in US, there is also a provision of what, like when we say the Council of Ministers in India are responsible to the Lok Sabha. Collective responsibility, yesterday we dealt with it. Collectively responsible to the Lok Sabha. So in that case, what will happen is that if the Lok Sabha, if the Council of Ministers loses majority, they go out of office together. In US, there is a Council of Ministers that are basically appointed by the president. The president appoints the Council of Ministers. They are all working in the pleasure of the president. It may so happen that these Council of Ministers remove the president. Yes, there is a provision in the Constitution of US wherein the Council of Ministers can also remove the president. But what is the ground? If they find that the ground is that the president, because of some reasons, is not able to discharge his responsibility, his duty as the president, if they find like he has become mentally incapable of doing it or something like that, in that case the Council of Ministers that are there, they are not called as ministers, they are called as secretaries. Secretary of State, Secretary of Defense, they are called as secretaries. So if these secretaries decide, they can do what? They can remove the president. On this ground, there is something called as the 25th Amendment or something there. And they can evoke that 25th Amendment and remove the president. If they remove the president, who becomes the next president? The vice president. Clear? So whenever we talk about the vice president in US, though the vice president in US is not necessarily elected, but if it so happens that the president in any way is not able to discharge his duties as the president, whether he is impeached, whether he dies in office or something like that, in that case the vice president automatically is sworn in as the president and he discharges his duties as the president. He discharges his duties as the president. Clear? So if you compare the vice president of India to that of vice president of US, in normal circumstances, both the offices that are there, they are very similar. Why? Because they do not have any kind of real executive powers. Vice president also has no real executive power. Neither does the vice president of US have any executive powers. Unlike that of India, vice president has no duties with respect to their legislature. In India, vice president acts as the presiding officer of the Rajya Sabha. That is not the case when it comes to the vice president of US. But unlike India, if the president of US, anything happens to the president of US or he is impeached from office or something like that, in that case the vice president becomes the president. He is not just carrying out this particular function or duty for the remaining time. He is not doing this that till the new president is actually elected. No, he does it for the remainder of the tenure. So there is no elections. There is no provision of elections that is there. In US, the president is generally not elected. Once he is elected, he remains in office for 4 years. He remains in office for 4 years. There are some contingency plans that are there, and through that contingency plans, they actually take up these ideas. So in US, there is a chain of If the chain says, okay, first individual, president. If he dies, vice president. If it so happens that the vice president is also dead or the vice president is not able to discharge his office, then one member of the cabinet Any one member of the cabinet can be sworn in as the president. If the cabinet is also not there, then in that case there is one member of the House of Representatives. Now the Speaker of the House of Representatives becomes the president. If the Speaker of the House of Representatives is also not there, then one individual from the House of Representatives, that individual becomes the president. So there is a chain, and elections are not warranted. It happens only once. In India, that is not the case. Clear? So the executive in India is elected, and if it so happens that in any way the executive loses the confidence, then elections are due. Again, if it so happens that there is a hung parliament or something like that. Clear? This is the office of the president, not that very important. Clear? But remember, he is removed by an effective majority. This is a question that can be asked in your prelims examination. Removed by an effective majority under, it is Article 67 Clause C and not Article 69. It is Article 67 Clause C, and under Article 67 Clause C he can be removed. Clear? Now we move to the Council of Ministers. Who conducts the election to the office of the Vice President? Election Commission of India. Like that of the President, Office of the President, the organization that is involved or that is responsible for conducting elections to the office of Vice President is the Election Commission of India. So Election Commission of India, what is its responsibility? Conducting elections to the office of President, Vice President, Lok Sabha, Rajya Sabha. Conducting elections to the office of the President, Vice President, Lok Sabha, Rajya Sabha and state legislature, also the state legislature. So Parliament, state legislature, President, Vice President, all these offices that are there, the elections to these offices are conducted by the Election Commission. Clear? Next, Council of Ministers. Council of Ministers. See, in a parliamentary form of government, the real executive authority lies with the Council of Ministers, not the President, not the Vice President. It is the Council of Ministers that enjoy the real executive powers. As we have already seen in yesterday's class, Article 74 of the Constitution, Article 74 of the Constitution says what? There shall be a Council of Ministers headed by the Prime Minister to aid and advise the President. Such an advice can be sent for reconsideration, and after due reconsideration, if the advice is sent back to the President, it becomes binding on the President. So it is the Council of Ministers who enjoy real executive powers. So whenever we talk about the parliamentary democracy has three cardinal principles. What are these cardinal principles? These cardinal principles are that first, the President is the head of the state. The President is the head of the state. Now this individual can either be the President or some other individual. Not necessarily the office is always called as the President. Clear? Like in British parliamentary system, this is the Crown. They are the head of the state, not the head of the government. Clear? That means this is only the nominal head. Nominal executive or the nominal head. Second, the real executive powers. It lies with the Council of Ministers. It lies with the Council of Ministers headed by the Prime Minister, and they are responsible to the lower house. They are responsible to the lower house. Third, Council of Ministers are Council of Ministers belong to the legislature in our case the parliament. They are all the members of the parliament. See, the Council of Ministers in India, they may not necessarily belong to the parliament, but to continue, when they are being appointed, anyone can be appointed as the Council of Ministers, anyone. But to continue as a member of Council of Ministers, they have to get membership to the parliament. Like very recently, in the new Council of Ministers after general elections, our External Affairs Minister, he was appointed as the External Affairs Minister, but he was not the member of Parliament. He has to become the member of Parliament within 6 months, and accordingly he filed his nomination from Gujarat and now is the member of Parliament from Rajya Sabha. But you can belong from Rajya Sabha, you can belong from Lok Sabha, but you have to be the member of Parliament. To continue as a minister, you have to be a member of Parliament. In UK, you always have to be a member of lower house. Unlike that of India, like a Council of Minister can belong from either upper house or lower house. There, the provision says that you have to be a member of lower house. So you will find that there the ministers that are there, they are belonging to the House of Commons, it is called as House of Commons. Unlike there the upper house is called as House of Lords. Like in US, House of Representatives is the lower house and Senate is the upper house. Clear? So in our case, it is Lok Sabha and Rajya Sabha. Lok Sabha is the lower house and Rajya Sabha is the upper house. Clear? So see, what are the 3 cardinal principles? President is the head of the state, but he is only nominal head. The real executive power lies with whom? The Council of Ministers. This Council of Ministers are responsible to the Lok Sabha. Yesterday we talked about collective responsibility. Council of Ministers belong from the legislature. These are 3 cardinal principles. If you compare this to the presidential system, you will understand why I am saying this as cardinal principles. See, there is the president the head of the state there and not the executive head? No. There the president is both the head of the state as well as the executive head. He enjoys both those powers. Second, who is the real executive? The president. Is the president answerable to the legislature? No. The president there, neither the president attends the meeting of the legislature nor is the president responsible to the legislature. Like in India, there is something called as Council of Ministers being responsible, collectively responsible to the Lok Sabha. Such provisions are not there when it comes to a presidential system. The president is not responsible to the legislature. And third, Council of Ministers belong to the legislature. There, who are the Council of Ministers? Secretaries. Are the secretaries belonging to the legislature there? No. They are appointed by the president, and any individual can become as a part of Council of Ministers, and they work on the pleasure of the president. And what did I mean by pleasure of the president yesterday? What did I say? What is the meaning of this phrase? Yes?
President can remove them.
Yes. President can remove them at any given point. So if the president wants, the president can remove any individual there also from being a part of Council of Ministers. Clear? Absolutely clear. This is that is the reason why if you look at these three provisions, we can we can differentiate these provisions from the presidential system, and that is the reason why these three provisions are called as the cardinal principles of parliamentary democracy. Clear? Now, when we talk about the existence or formation of Council of Ministers, how is the Council of Ministers formed? As soon as the Prime Minister takes oath, we deem that the Council of Ministers have been formed. As soon as the Prime Minister takes oath, it's not necessary for every Council of Ministers to take oath and only then it is deemed that the Council of Ministers have come into existence. No. As soon as the Prime Minister takes oath, we deem that the Council of Ministers have come into existence. Example, Maharashtra. What happened? In the morning 6 o'clock, Devendra Fadnavis took oath as the Chief Minister. And one individual also took oath as the Deputy Chief Minister, Ajit Pawar. Was any other individual appointed as a member of Council of Ministers? Absolutely not. No individual was appointed as other Council of Ministers. In fact, even if Ajit Pawar would not have taken oath as the Deputy Chief Minister, still only when the Chief Minister takes oath, because the position of the Prime Minister is very similar to the position of the Chief Minister. Exactly similar. It is exactly similar. So once the Chief Minister takes oath, like in this case the Prime Minister takes oath, the Council of Ministers is said to have been formed. It is said to have been formed. There is no need for any other minister to take oath. Yes, once they have to occupy office, they cannot occupy office without taking oath. But formation of Council of Ministers is not dependent upon other ministers taking oath. It is only dependent upon whether the Prime Minister has taken oath of office or not. That's it. Prime Minister has taken oath of office, it is said that the Council of Ministers have been formed. Clear? Understood this idea? Now, if you think you are going to forget this very idea, what I have said, that as soon as the Prime Minister takes oath, the Council of Ministers are formed, please write it, so that you don't forget, because I know you are going to. जब मैं आज बोलता हूं तो आपको कल याद नहीं होता, तो मैं ये कैसे अज्यूम कर सकता हूं कि अगले साल आपको याद रहेगा? See, when we say Council of Ministers, the Council of Ministers can be classified into three. Based on their rank that they enjoy within the Council, they can be classified into three. The senior most ministers are called as Cabinet Ministers. The second in command are called as Ministers of State, MOS. And finally, there is something called as Deputy Ministers. Who is a Cabinet Minister? They are obviously senior most. They are the senior most ministers. Generally, the 10 to 12 senior most ministers are classified as Cabinet Ministers, but the number can vary. Generally, 10 to 12 ministers are considered to be Cabinet Ministers. These ministers they are given separate portfolios. They are given separate portfolios. The body cabinet is headed by the Prime Minister. They are headed by the cabinet, by the Prime Minister. Clear? So, what is cabinet? Cabinet is the senior most, remember this, cabinet is the senior most decision making body in the country. It is the senior most decision making body in the country. And generally it comprises of 10 to 12 senior most ministers. All these ministers that are there, they enjoy the right to attend cabinet meetings. That means if the Prime Minister convenes cabinet meeting, those individuals who have taken the oath of being a cabinet minister, that individual automatically is invited to the cabinet meeting. Now they are automatically invited if the Prime Minister convenes the cabinet meeting. They are given separate portfolios. Now what is the meaning of this separate portfolios? It simply means ministries. All of them enjoy this particular status. They get what? They get separate ministries. Clear? Second in command is Minister of State. They are second ranking ministers. They are second ranking ministers. They generally assist the cabinet ministers. However, they can be given a separate portfolio. They do not enjoy the right to attend cabinet meetings. They do not enjoy the right to attend cabinet meetings, but can be invited to one. But can be invited to one. These are the ministers of state. See, they are second ranking ministers. They generally assist the cabinet ministers. So you will find that, like, now the Prime Minister also has some the Prime Minister has some offices also that some ministries that he heads. Generally you will find there is something called as a Ministry of Personnel. Ministry of Personnel, Public Grievances, etc. that is there. It is headed by the Prime Minister. And there is a minister who assists the Prime Minister in discharging the duties. Right now that individual is Jitendra Singh. Now from Jammu and Kashmir, he is the one who actually assists the Prime Minister. He is called as Minister of State for Personnel. So why I am saying personnel? So all recruitment etc. is done by this particular office. Clear? This is the office that decides what is UPSC pattern etc. etc. It is up to them. It is completely their discretionary powers. Clear? They are second ranking ministers. They are generally there to assist cabinet ministers. However, they can be given separate portfolios. They can be given separate portfolios. Like in India, the last that I remember, it may so happen that in the last ministries also, some of them were given separate portfolios as well. Some of them were given, like, I think there is a minister called as Harshdeep Puri recently, and that individual has separate ministries. Though he is not a cabinet minister, he is a minister of state, but he is given separate portfolio as well. Separate portfolio is given. They do not have the right to attend cabinet meetings. So they are not automatically invited to cabinet meetings, but they can be invited to cabinet meetings. Though they do not have the right, but they definitely can be invited to cabinet meetings. Clear? These are the ministers of state. Third is deputy ministers. They are the lowest ranking ministers. Lowest ranking ministers. They assist the cabinet or minister of state. They are not given portfolios. They are not given separate portfolios, and they do not have the right to attend cabinet meetings. They do not have the right to attend cabinet meetings, neither can they be invited to one. Neither they can be invited to the cabinet meetings. Lowest ranking ministers. See, actually in India, though previously we used to appoint deputy ministers, but now this is not the tradition. This tradition has been done away with. In fact, the last prime minister, the last cabinet that council of ministers that appointed deputy ministers was the Rajiv Gandhi cabinet. So it's been more than 30 years since the last deputy minister was appointed. Provision is there, they can be appointed, but generally we have done away with this tradition, and now within the council of ministers there are two types of ministers. Either you are cabinet minister or you are a minister of state. Clear? These are the three these are the three members in the council of ministers. Out of these three bodies, I said cabinet is the highest ranking. Is cabinet a constitutional body? Is cabinet a constitutional body? Now, in the constitution, do you find a word cabinet, or everywhere there is council of ministers that are mentioned? Council of ministers are mentioned, and the term cabinet is then an extra constitutional body. If it is not mentioned in the constitution, which means it is an extra constitutional body? Bilkul galat hai. There is only one article in the constitution which mentions the term cabinet, and hence it is a constitutional body. It is a constitutional body. However, in original constitution, the term cabinet was not mentioned. The term was added. The term was added by the 44th Constitutional Amendment Act, before the 44th Constitutional Amendment Act, that is before 1978, the term cabinet was nowhere found in the constitution. So then it was an extra constitutional body. Now we have included it as a part of the constitution. Article 352, what does it deal with? Yes, it deals with national emergencies. And now post Indira Gandhi declaring emergency, clear? How did Indira Gandhi declare emergency? In 1975. She called the President of India, Fakhruddin Ali Ahmad, who was the President. She called him somewhere around midnight and asked the President to proclaim emergency. And the President on midnight, I think it was 6th of June or something like this, and he declared national emergency. So that this never happens. Fakhruddin Ali Ahmad was defined, or he was described as something called as yes president. Yes president. He always used to say yes to whatever the demands of the cabinet was or the prime minister was, not looking at whether it was constitutional, unconstitutional, any of such thing. So these individuals like Fakhruddin Ali Ahmad, he was described as the yes president. So he was called around midnight by Indira Gandhi, and rather than sleeping and saying no, I will not attend the call, he attended the call, and Indira Gandhi said, declare emergency, national emergency, and he declared at midnight. See, if you look at the constitution, original constitution under Article 352 said that the President will proclaim emergency, but the provision was what? Always on the recommendation, aid and advice of the Council of Ministers, headed by the Prime Minister. Nowhere it is mentioned the Prime Minister will say and the President will proclaim emergency. But he did that. So that this does not or is not repeated, the Janata Party, when Janata Party came to power, they amended the constitution. Specifically the national emergency provisions that were there, it was amended. And now Article 352 says, the President will proclaim emergency on the written recommendation of the cabinet. Written recommendation of the cabinet, not just recommendation. It says written recommendation of whom? Not the Council of Ministers, the cabinet. So yes, cabinet is a constitutional body, and it is only in one of the articles the term cabinet is mentioned, and that is Article 352 of the Constitution. That too post the 44th Constitutional Amendment Act. Originally it was not mentioned. Clear? Understood this idea? So these are the three kinds of ministers that are there in the Council of Ministers. The 91st Constitutional Amendment Act, the 91st Constitutional Amendment Act in 2003, this 91st Constitutional Amendment Act in 2003 did what? It imposed a limit, maximum limit to the number of Council of Ministers, and it says what? It says 15% of the Lok Sabha. That is the total strength of the Lok Sabha, which is 545. So there are the maximum number of members that can be appointed to the Council of Ministers is 15% of 545. 15% of 545, somewhere around 80 members. No, एक दो ऊपर नीचे है, ठीक है? Somewhere around 80 members, that can be the maximum strength of Council of Ministers. Clear? So even the Constitution imposes a restriction on the number of Council of Ministers. So these are the three types of Council of Ministers, three categories of Council of Ministers, and there is a limit to the total strength, which is 15% of the Lok Sabha. In case of union, In case of state, it is 15% of the state legislative assembly. Clear? 15% of the state legislative assembly. See, there is one more body that exists, though it is not the part of Council of Ministers. That body is called as Parliamentary Secretaries. This body is called as Parliamentary Secretaries. They are appointed by whom? The Prime Minister. So their oath of secrecy that is there, it is administered by whom? By the Prime Minister. So, are they the members of Council of Ministers? No. Who appoints the Council of Ministers? The President. Who administers their oath? The President. So, when the Prime Minister is appointing them or the Prime Minister is administering oath, are they the members of Council of Ministers? No, they are not. They are not the members of Council of Ministers. They are just Parliamentary Secretaries. They are not the members of Council of Ministers. Remember this. They are not. If you have to write, please write it. Not. They are not the members of Council of Ministers, because some of you are mentally absent. So unless you write down this, you are going to forget it. So they are not the members of Council of Ministers. They are there to assist ministers, like the Minister of State, or for that matter deputy ministers, who are there to assist cabinet or the ministers of state. They are also appointed to assist ministers. They are also appointed to assist ministers, but to assist ministers for what? Their responsibility towards the parliament, or to discharge their responsibilities as a member of parliamentary committees. Some form of committees, etc. that are there. So they they are specifically appointed for this very purpose. There is no other purpose that they serve. Clear? They are assisting ministers to discharge their responsibilities in the parliament. So, in parliament, ministers are asked questions. Now, they are asked questions. And when they are asked questions, so in certain cases, like if we talk about, suppose, policies and programs, different policies and programs. See, you cannot expect the minister to know everything about a policy and program. That how it is being implemented, etc., etc. So if that is the idea, so not necessarily this individual, the minister, will be able to properly answer all the questions. So to discharge their responsibility to the parliament, what happens? There is an individual who may be appointed by the Prime Minister as a parliamentary secretary, and he does what? He helps the minister. See the name, Parliamentary Secretary, which means any responsibility that the minister would have with respect to the parliament, to discharge those responsibilities, a parliamentary secretary is appointed. He is not the part of Council of Ministers. Okay? Now, why I am focusing on this? Because if you look at maybe the previous versions of Lakshmikant, उसमें ये दिया हुआ है. It is wrong. No, it is wrong. I don't know about this version, new version which you have bought. Previous versions में ये लिखा हुआ था. It is wrong. Parliamentary secretaries, this office that is there of parliamentary secretaries, this office of parliamentary secretaries are right now not being appointed in the center. It is appointed in the states. These are appointed in the states. And there was a recent controversy over it. Why? Because in the legislature of Delhi, NCT of Delhi, National Capital Territory of Delhi, the legislature that we have, it says what? It says that the maximum strength of this legislature is 70. The maximum strength is 70. And this maximum strength If you look at the provisions of Article 239 AA, I will be talking about it later on when I come to Delhi legislature. You would find that unlike the 91st constitutional amendment, which prescribes 15% limit in the Lok Sabha, in Delhi legislature it is 10%. The Council of Ministers, the maximum limit of Council of Ministers in Delhi, it is 10%, not 15%. Unlike other states, or for that matter Parliament, Union, here it is only 10%. Clear? Now what happened? Dekho, Delhi legislature, election happens, Aam Aadmi Party wins 67 seats out of 70. But they can appoint maximum 7 individuals as Council of Ministers. Baki ke 60 ka kya? 60 of them. Remaining is 60. And Aam Aadmi Party was a new party. It was not old that okay there was hierarchy that तुमने पहले join किया और हमने पहले बाद में join किया, ऐसा तो था नहीं. Most of the members that were there, they were new. So what happened? Then there were certain problems that started. Why are you appointing that individual? Why not me? मैं छोड़ दूंगा, etc., etc. All these ideas started. So what they did was, what the Council of Ministers they did there was, they appointed 21 members of the Aam Aadmi Party, of the members of the legislature of Delhi who were elected from the ticket of Aam Aadmi Party. They were elected, they were appointed as parliamentary secretaries. As I said, the office parliamentary secretaries are no more in existence. They are generally not appointed in the parliament. They are appointed in the state legislature. And now there are a lot of state legislatures who appoint them. State of Bihar, you will find some individuals appointed as parliamentary secretary. That is also the case in Bengal. That is also the case in Gujarat, etc., etc. But the scenario of Delhi is a bit different. Why? Delhi has special status. What is the special status? They don't have special status. That is the special status. So in certain cases, what happens is here, whenever a bill is passed, whenever the bill is passed, the bill that is passed by legislature, it goes to the lieutenant governor, and lieutenant governor sends the bill to the president, and the president may reject the bill. Even if it has been passed by the legislature, the president can reject any bill that has been passed by the legislature. Delhi, that is the case. And further, the Council of Ministers that are there in existence here, they do not enjoy the same kind of executive powers that are enjoyed by other states, Council of Ministers in other states. So Arvind Kejriwal realized this later on. Okay, गलत जगह से लड़ लिए. ठीक है, बहुत he realized this, and that is the reason why when elections were happening in Punjab, so he wanted that if Aam Aadmi Party wins in Punjab, so he will shift to Punjab. Why? Because that is a full state. Delhi is not. So here there were a lot of problems. One of those problems that came up was this: the office of parliamentary secretary. Now, in a class or so, most probably in 1 or 2 classes, I am going to come to a topic called as parliament. And when I come to the topic parliament, I will be discussing a topic called as Article 102, which deals with disqualification of members of the parliament. There we are going to talk about an idea called as office of profit. That means, as an individual, when I am elected to the office of being a member of parliament or being a member of state legislature, any legislature for that matter, I cannot hold any office of profit. If I hold an office of profit, that means office under the government. If I hold such an office, I am discharging some executive powers, I can be disqualified from being the member of the house. It happened. Again, 2006 itself, Sonia Gandhi was about to be disqualified before there was an amendment passed to the office of profit bill. Similarly, Jaya Bachchan, who was a member of Rajya Sabha from Samajwadi Party, she was disqualified because she held an office in censor board, and that was an office of profit. So she was disqualified. No individual can hold any office of profit and also be the member of legislature, whether it is union or for that matter state, or for that matter, like in this case, it is NCT. So see what happened. What happened was that in this particular office, parliamentary secretary, because they enjoy some executive powers, they are helping the ministers, and in discharge of their duties, in helping ministers, they are enjoying some powers, executive powers. Though they may not necessarily get salary, etc. They may or may not get that, but they definitely enjoy some executive powers. So 21 members of the Aam Aadmi Party they were appointed as parliamentary secretaries. The thing is that when the state of Bihar, when the state of West Bengal, or when the state of Gujarat appoints parliamentary secretaries, there they have passed an amendment act, and that amendment act has done what? They have exempted the office of parliamentary secretaries from being office of profit. That is exempted under that particular state. In Delhi, what they did was they first appointed office to these 21 members to parliamentary secretaries. Then they realized, okay, we have made a mistake. So they passed a law. Because they have 67 members, it is easy to pass a exemption law. So they passed an exemption law, but when the exemption law was passed, it goes to the lieutenant governor. And lieutenant governor, wo to center ka aadmi hai. He reserves the bill for the consideration of the president. President rejects the bill. So parliamentary secretaries are appointed, they are working, they are acting, they are exercising all executive powers, but the office was not exempted from being office of profit. 3 members थे बीजेपी के, उन्होंने हो हल्ला शुरू किया, and the election commission took this very idea and recommended to the president that you should disqualify these 21 members. The president disqualified them. That you cannot hold office of profit. The president disqualified these 21 members. They went to the Delhi High Court and challenged the disqualification on the grounds that the election commission did not interview them. The election commission did not take up their point of view, they did not interview them. Now, the Delhi High Court upheld the stay on their disqualification on this very ground, that you did not interview the 21 members. Because what does the principle of natural justice say? Audi alteram partem. No one will be punished unheard. And this was a violation of natural justice. तो बच गए. These 21 members that were there, they were disqualified by the president, but they were saved because of this very idea, because the High Court directed the election commission to take up the matter again. But obviously election commission के पास सिर्फ यही काम तो नहीं है. So the election, because of it getting delayed, etc., those things were not taken up, and now the elections are almost due in Delhi. So they were in office. They initially enjoyed this position of being a parliamentary secretary, and they could continue. Why? Because the election commission once recommended the president, but the Delhi High Court stayed that particular order. Clear? So this parliamentary secretary that is there, they enjoy executive powers, but they are not the part of Council of Ministers. They are not the part of Council of Ministers. Clear? Understood this idea? Because this parliamentary secretary idea that is there, initially we were expecting that as soon as the disqualification happened, so most probably we were expecting that questions might appear, but it did not. No, it did not. So it is still continuing that, it might be asked. Remember, the oath of office is administered by the Prime Minister, not by the President. They are not the members of Council of Ministers. They are generally there to assist, but they are not the members of Council of Ministers. Clear? With this, I complete my discussion today. Tomorrow when we meet, I'll give you an outline about the idea of, again we'll discuss that idea of collective responsibility and individual responsibility. Just a brief before, because I've discussed that. I'll elaborate upon it. And then we move to the office of the Prime Minister. We discuss the office of the Prime Minister, some other peripheral aspects. And tomorrow, most probably we are going to complete all of this. So when we meet after tomorrow, we are going to take up we are going to start a discussion on the Parliament. Clear?